Welcome, everybody. I'm going to talk to you all today about patent strategy and give an introduction to patenting. If any of you have any questions, please just go ahead and raise your hand or ask a question in the Q&A or the chat, or just jump right on the call. Feel free to keep it interactive. So yeah, so my name is Steve Leonard. As Ahmed was saying, I've been in patenting for quite a while. I started off as a PhD student, patenting some technologies during my graduate work, and then joined the startup, worked in a startup role from a research perspective first, and switched over to the business side and became a patent agent, and then co-founded Cuvella Corporation. As Ahmed was saying, we are a Series B stage diagnostics company. We're making a rapid sepsis detection device. It's a microfluidic device that can detect one bacteria in 1 mil of direct whole blood, so that we can identify the bacteria for determining the appropriate antibiotics to prescribe for people who are present to the ED with sepsis, for example. And we can do that in about an hour, so it's very quick. And we've been at it for about 10 years, and we're now actually launching our first product. We've got it in a number of different hospitals in the US and Europe, so it's a really exciting time for us. So I have this dual role where at Hill & Schumacher, I'm a patent agent, and I work with a lot of startups and teaching hospitals. And on the rest of the week, I work at Cuvella, so it's a really fun role. And I started off just like you guys. So I'm going to start off here, hopefully, there we are. So I'm going to start off just by giving you a brief introduction to patents. I can't really ask for a show of hands, I think, in terms of who's seen a patent before. That's what I would normally do if we were in person. But I'm guessing some of you have and some of you haven't. And once I show you what a patent looks like, then we're going to get into an introduction to a lot of concepts in patenting from the dual perspective of publishing versus patenting. Because as a student, I was very familiar with the world of publishing, but the world of patenting sort of came as a cold shower. A lot of it didn't make sense to me. So I found that teaching this way, this heuristic way with patenting and publishing, is a really good way to introduce a lot of concepts in patenting. So we will, I'll teach you a number of different aspects of patenting through this comparative analysis. So hopefully you can see this slide, Anatomy of a Patent. This is a representation of the structure of a patent or patent application. It involves a specification, which is when you open up a patent or you look at a patent, you've got an abstract, some drawings or figures, and then a written description. And then at the back, you've got these crazy, really obtuse, obscure, apparently run-on sentences that seem to be made of this strange language that patent agents seem to have come up just to confuse people. So the first time you read a patent, it'll seem very, very odd. So hopefully I'll explain some of the reasons why we write the way we do. But the key thing is the claims are, it really is what it is. You're staking your claim. It's where you draw the line on the sand, in the sand, and you're saying, if you do this, you are going to, I can sue you with this patent. So it's where you basically are saying, what lines an infringer has to cross in order to be infringing your patent. So, I mean, that's really what a patent is about, laying down that line. So why would you have to do all this other stuff, the description and the figures and the abstract? After all, there you're just disclosing, you're just telling all about your invention and stuff you'd rather keep secret. So the reason for having all that is because you're only entitled to have a claim if you've properly described and supported the scope of that claim. So you want to have a generic claim, a claim that is very broad, so that you're going to capture infringement in a lot of different ways, not just the specific way that you came up with. And that's our job as patent agents, to try to come up with those claims and make them as broad as we can. But in order to support that claim breadth, we have to make sure that we've described the invention in a lot of different ways, in a lot of different detail. So I like to think of the claims as this genus of the invention, a very high-level abstracted version of the invention that is more abstracted than the invention that you would have come to me with as an inventor. And then the description and the figures are going to be describing your implementation, your idea, but also a number of different forms of it. And that way we've got a lot of different species of the invention described here that motivate and support the genus and the claims. So that was an abstract description. Let's get into an example of a patent. So this is actually issued as a patent now. It's a patent application I'm showing here. So on the left, and I'm just going to see if I can get the. I'm just going to try to get the laser pointer here. There we are. So hopefully you can see this now. Let's see. So this is a patent, the cover of the patent over here. This is one of our patents at Qvella. And there's the title of the patent. There's the applicant, which is Qvella. There's the inventors. I'm one of the inventors on this one. Bunch of details about the patent, and then the abstract, and then a representative figure. So this is what the cover of a patent looks like. The publication number is up here. There's an issued version of this now with an issued patent number. And this is just zooming in here on some of the details of the patent. As you can see, lots of details here. There's classification numbers here. These are sort of different categories that the examiners classify this patent under, so that if you're going to search for similar patents, you can look up these classification numbers and see related patents. So that's why they're there. And then the abstract here, which is a very brief summary of what this patent is about. And this one is actually about our cartridge that does all the fluidic processing. We take a blood sample, it goes through. There's actually a centrifuge tube designed into this cartridge. It centrifuges the blood, separates the bacteria, electrically lyses the bacteria, and then goes through to an array. This all gets sandwiched together. This is an exploded view, where we do RT-PCR and identify the bacteria. So to describe that, let's see. So this is a couple of pages from the description of the patent. Lots of content here, a bit of a background describing what the invention was about. Again, a summary, and then a detailed description over here that's going to go on for pages and pages. And this is, again, giving the full details, all of those details that are going to support a broad claim. We're going to have some figures. These are generic figures describing from a very high level what the invention is about. This is a high level version of a centrifuge here with the centrifuge rotor. A couple of cartridges go in. We've got a robot that interfaces with it, and we can drive the fluids around in our cartridge while at the same time centrifuging. And this is our cartridge here, schematically shown. So, like I said earlier, that the heart of the patent is the claim. This is our claim 1, and this is a claim about, it's a method for performing centrifugal separation and microfluidic processing using an integrated fluid processing cartridge. So that's the preamble. We're kind of setting the stage for what the claim is about. And then we've got these different elements of the method. We've got, we're using this type of integrated fluid processing cartridge, and then we've got our method steps here about what we do. And it's all one super long sentence. And in order to infringe this claim, you need to be doing everything in this claim. So hopefully that gives you a bit of a brief introduction into what a patent looks like. I'm going to ask you guys for homework to do some patent reading of your own in an area that's interest to you. Before we do that, we're going to continue on here, and I'm going to walk you guys through some differences between the world of publishing, which is what I came from as a graduate student, and the world of patenting, in which I've been living for the past 15 years or so as a patent agent and working in industry. So before we do so, we'll just talk about what some of the motivational differences for trying to publish a paper versus filing a patent application. So you're going to publish a paper for a lot of reasons. You've got some great new results that you've come up with as a researcher. You want to disseminate the knowledge. You want to get credit for your work, because publications are the currency of academia, where you get credit and you get advancement. So you want to improve your CV through that, and hopefully get a new academic position or a grant application. So very different reasons for filing a patent application. A patent application, you're going to file for business reasons. You're going to file for monetary reasons. Patents are filed to maintain market share by blocking others from being able to do things. Patents that are granted are exclusionary devices. They block others from being able to do things. But there's a few other reasons as well why you'd be interested in filing a patent application. Another option is to generate licensing revenues through a patent filing. So even if you're not necessarily going to practice the invention yourself, you can get licensing revenues by licensing your invention to somebody else. Maybe you're going to use your invention in one narrow domain, and you can still license it to a company in another field, for example. Filing a patent application is critical to protecting investment in R&D. No company, no investors would sign up for supporting an R&D project if there wasn't the ability to protect the outcome of it. So patenting is critical in startup companies that are R&D based to be able to at least hope for some measure of protection after spending years and millions of dollars in developing a product. Patent applications are also important when you're starting a company. Investors are going to want to see that you filed a patent application. It's going to be one of those boxes that you need to have checked if you're going to go out and ask people for money. They won't necessarily do a deep dive and deep analysis on your patent application, but they're going to want to see that you followed through and you've actually attempted to protect your IP. Patents are also important in companies to demonstrate innovation. You'll see this often described in articles about Canada needing to be more of a force of innovation and file more patents, and companies often do that. You see IBM, for example, so many patent filings, and they're clearly seen as an innovator as a result. And patents are also strategic tools. They can be used often as building up a war chest of patents, so that if you're engaging commercially and you're bringing products to market, you have competitors and they have their own patents, you sort of each come at the battle with weapons, and you can deploy strategies in the market in order to compete, and patents are a part of that. So now I'm going to get into some of these comparative differences between patents, between publishing and patenting. And I hope you're all still with me. It's hard where I can't see the audience, but again, if anybody has any questions along the way, please feel free to speak up. Okay, so the first and one of the most important ones, one of the ones you'll likely encounter first, coming from as being a student and entering the world of patenting, is authorship versus inventorship, and the difference between those. It can seem confusing, but there's a huge difference between those two things. So authorship applies to papers, so academic papers and journal submissions. So who can be an author? Well, just about anybody who contributed to the work. Sometimes if it's experimental work, for example, some research technician who helped, they're often included as an author, even though they didn't really conceive of the experiment or contribute to the real thinking behind it, but they helped, and they often get an authorship as a result. The same goes for professors. Sometimes professors aren't really that engaged, but they're the professors, so they get their name on the paper. Definitely seen that. And sometimes these names are added out of respect or favor or political necessity. That can result in a lot of names on a paper. This one here comes from a former life of mine. I'm not on this paper, but I used to work in the field. I did a master's in gravitational wave theory, and this is the paper that led to ultimately led to the Nobel Prize which was the observation of the binary coalescence of a couple of black holes. This had about 2,000 authors on it. So huge work, lots of people, collaboration, big collaborations, lots of authors. You wouldn't find a patent application with 2,000 authors. It's rare to find one with more than 5 or 6 inventors, for example. So inventors apply to patents. Authors for papers, inventors for patents. Inventors, unlike authors, are those who make inventive contributions. And it's not just like contributions to the drafting of the patent description or the figures. It's they need to be able to point to claims that are submitted as part of the patent application and say, I made a non-obvious contribution to that idea. That does seem abstract, but it is a more clear sort of guidepost than in the academic world. So to be an inventor on a patent, you can't just be carrying out the work of someone else. You actually have to be contributing inventive thought, and you need to be able to do that. And during prosecution is as the patent goes through the examination phase with working with the patent office before you get an issued patent. Sometimes some of the claims get rejected and knocked out. So because of that, inventorship can actually change during prosecution. And another thing is that inventorship does not necessarily imply ownership. So patent ownership technically does start from inventorship. If you're an inventor and you haven't assigned any of your rights to an institution or a company, then you're also the owner. But usually, especially for students, in some institutions, but not in others, for example, at U of T and through Sunnybrook, there are IP policies where you are obligated to assign your rights and the IP to the institution, and there's rules about how that process plays out. So just because you're an inventor doesn't mean you're necessarily an owner. You may have already signed agreements that convey some of your patent rights to a larger entity. Okay, so that is inventorship versus authorship. Another one is disclosures. This is a huge one. When you go to, you've got some new idea, academic idea that you've come up with as a researcher, and you want to go present it at a conference. You'll publish, often you'll go to a conference and you'll present prior to publishing. And you really want to get your idea out there as soon as possible because you want to get credit for it. You want to be, the person who's cited as the first person to have come up with that idea. Whereas in the world of patenting, if you make a public disclosure like that without actually filing a patent application, in most countries of the world, it's like giving away your idea. So this is a key lesson, that if you've come up with something that you think, wow, this could be a patent, this could be something commercial, you got to press pause on your instinct to get out there as a researcher, as an academic, and talk about it and evaluate really whether or not there's potential IP. Talk to your tech transfer group or officer, and really think about if there's a patent application that needs to be filed before publication occurs. So public disclosure, I've been talking about this, a public disclosure and its effect on patenting. Well, what can that be? It can be a lot of different things. It could be online publication of a paper or an abstract. And this often happens. Sometimes you submit a paper and it can be, months before it's accepted and it publishes. But sometimes the journals, because they want to get their articles out there early, they'll actually publish it earlier than they had told you. And that can be bad because then if you haven't filed your patent application yet, suddenly you're making a public disclosure. Other examples are conference presentations or posters, or public demonstrations of the invention, in the US, a public offer for sale. So this is even if you're going to prepare to sell, even if you're offering to sell the invention, that's considered a disclosure. Now, a lot of countries have a 1-year grace period, which means that, let's say you went out today and disclosed your invention, went on the news tonight and talked about it. In the US, in Canada, in Australia, in Japan, and a number of countries like those, you would actually have a year to file your patent application. They have a grace period. But other countries, such as all of Europe, China, you know, those big jurisdictions, they don't have that. So you would have lost your ability to get a patent in those big countries. So yeah, the key is in most for protection in most of the world, you've got to file a patent application prior to the public disclosure. And like we've talked about, the patent application has to have a lot of meat in it. It has to have all those details that are going to support the broad claims. So you have to have sufficient detail to support the claims in that patent application prior to the public disclosure. So if there's one thing that you're going to remember about this talk, hopefully it's this one, because this is the one that's going to impact you the most early on. Another difference is publishable versus patentable. I would argue that the standard for papers, for publishing a paper, is novelty. So it just has to be new. And if you've got something new, you could probably, even if it's weird and sort of out there, chances are you can probably find a journal somewhere down the impact factor list that will publish it. Like this one at the bottom, this is an actual paper that was published, Pain over Speed Bumps and Diagnosis of Acute Appendicitis. So somebody actually did a study on that as a diagnostic measure and published it. In terms of patentability, there's 4 different criteria for patentability. The first one is usually fairly easy to meet. It's utility. So it has to have some kind of practically useful application, the invention. The next one, again, usually fairly easy to meet, is novelty. That means that there can't be a public or a written, a printed document out there that discloses your idea. A little bit trickier is non-obviousness. Non-obviousness means that someone who's skilled in the field, if you gave them maybe 2 or 3 different patent references or papers that were related to your invention, you would have to make sure that it wouldn't be obvious for them to combine those different teachings together and arrive at your invention. So this is, you can see this, you can imagine there's a lot of gray area here, and this is where us as patent agents spend a lot of time arguing with patent examiners in order to get patents granted. We're arguing about non-obviousness in view of prior art or patents that have been cited during patent examination. The 4th one is actually really important as well. It's subject matter eligibility. That's especially important in the medical field, because for some cases, such as inventions that are methods of medical treatment, the patent office, most patent offices will say, no, we're not going to give a patent on that. Because if we gave a patent on a method of medical treatment, then you'd be able to sue a doctor before the doctor treats a patient. And we all don't want that. We want doctors to be able to freely operate on patients. So there's various forms of subject matter that are actually barred from patent eligibility. And some other forms are naturally occurring substances like naturally occurring nucleic acids and other molecules. And some business methods are not patentable. And there's a lot of debate now about computer implemented inventions that are inventions to sort of computer algorithms. And if they are too disembodied from the computer, if they're described that way, the patent office and they're not shown to be like an actual improvement to the working of the computer, the patent office is going to reject those as being abstract ideas. So we've actually spent a fair amount of time arguing about subject matter eligibility as well. Okay, publication. So another difference is publication. This is a fairly easy one here. Once you publish your paper, that's it. You're done. Your paper gets accepted. It publishes. That's it. You've achieved, right? You've published your paper. You've got your credit. All good. In the patenting world, patent applications do publish, but that's just the first stage. So when you're searching for patent applications or patents, you go on Google Patents, for example, you're going to see issued patents, and you're also going to see patent publications. Now, just because a patent publishes doesn't mean it's actually going to issue. And it doesn't mean that the claims that are in the patent publication are going to be the same as the claims that eventually issue in a patent. So there's a big difference between publication of a patent application and actually granting of a final patent. Big difference there. So this kind of brings to light this issue of the patent bargain. The patents, the patent system is often described as being this balance between disclosure of your idea, which we would not want to do otherwise because it's a new and secret idea, for protection, for patent protection. And it's described as this sort of balance in terms of this equal weighing of the scales of disclosure and protection. But it's really not balanced properly because when you publicly disclose your invention through the patent publication, that doesn't mean you're actually going to get a patent out of it. The patent examination continues, and the examiner may reject your patent, and you might not get a patent out of it. So you have to think carefully when you're about to file a patent application as to whether or not it's likely you're going to get the patent claims awarded that you want, because chances are, if you look at the statistics, around 60 to 70% of patent applications eventually do issue as patents, but a very large, I would argue, a very large percentage of those are issuing with narrower claims, not the claims that the inventor had actually wanted, the broad claims the inventor had actually wanted. They're claims that are narrower or different because during patent examination, the patent examiners through patent references and prior art at the inventors and forced them to narrow the claims. And as a result, the scope of protection that they eventually got wasn't what they had intended. So something to think about carefully. Okay, another difference is content. So when you're submitting a paper, often you try, I remember this from my days in theory and physics, you try to make the papers as concise as possible with sort of the minimum amount of detail in order to convey the idea, and you left out details that were deemed to be easy or trivial. And you know, the difference, that's a big difference from patents. In patents, we usually like to put more. We like to have a lot of broad detail, a lot of description of the invention. And the reason is because part of the patent system, especially in the US, requires this duality of written description and enablement. So you have to have enough descriptive content within the patent application to prove that you actually had possession of the invention. It wasn't just like a concept. You actually fully, envisioned the invention in its full working capacity. And also enablement, so that if you gave your patent application to somebody who's skilled, they would actually be able to make and work the invention based on your description. So you have to make sure you have enough detail in the patent application to support both of those requirements. In a paper, you're often making broad, sweeping statements, a lot of, sort of throwing out there broad ideas. Whereas if you do that in a patent application without meeting these requirements of written description and enablement, without describing them in enough detail, you're not going to get support for those claims, and those claims can actually be deemed to be invalid. So the bottom line is patent applications need to be thoroughly described in order to support those claims. In papers, it can be beneficial to discuss the past work of others in detail. This is often done like kind of a historical perspective on a field in a paper, but we don't like to do that in patents because we don't like to sort of characterize. We don't want to be seen as biasing the patent examiner in one direction or another, because that could put our patent at risk. That could be grounds for invalidity. Also in papers, it's common to make prophetic statements. So a prophetic statement is, a statement saying, maybe this will work in the future, because the idea is you've sort of done your initial research and you're trying to extend it to the future and thinking about other ways in which you could do that. And you want to get credit for those. So that's why it's done. Whereas in a patent, if you make such prophetic statements, again, if you haven't described them in a lot of detail, you can't claim them. So if you make a prophetic statement in a patent application, and then you come back a couple of years later after you've done the work on it to actually make it work, and then you want to file a detailed patent application, at that point, the patent examiner can cite your earlier patent against you and say, well, you gave away the idea there, and you're in a bit of a catch-22 situation because you couldn't claim it in the original patent you filed, but you can't claim it in the other one either because it's obvious based on the idea in the first one. So you have to be really careful about making sure that anything you're going to say in a patent application is going to be something that's potentially going to lead to something that can be claimed. Okay. Another difference is international impact. So in the world of academia, in order to get credit for your idea, in order to successfully publish and have that publication recognized around the world, you can publish in one journal, doesn't matter where it is, and that's it. You've published, and you will be cited hopefully, anywhere in the world. Whereas in the world of patenting, if I file a patent application in Canada, it doesn't have any effect in the US. So if I file a patent application that issues in Canada, I've got a patent in Canada, but I haven't filed one in the US, I can only stop people from practicing the invention in Canada. I can't stop them in the US. So that means that patent applications have to be filed separately in each jurisdiction. And that might seem like a really hard thing to do because there are so many countries in the world, and if you want to protect your idea internationally, wow, how many, like hundreds of countries would you need to file your patent in? And that would get crazy expensive and completely unfeasible. Well, the way we handle that is we tend to patent in a few, maybe 5 or 6 countries usually that represent 80 to 90% of the market, especially in the case of medical devices, which are complicated and take a lot of effort and investment to bring to market. That's going to be enough to protect the broader market, and it's not going to be worth someone's while to go and service the smaller parts of the market that you're leaving behind. Another area that's important is the effect of your own past work. So in the world of publications, you might publish a paper, you might publish another one a couple of years later that's an extension of your first one, and then a couple of years later do another one. And again, you're sort of cumulatively building on your research, and that's a very common thing to do. Sometimes these are very incremental improvements you'll see that people are publishing. In the patenting world, however, you can be, when I get a patent disclosure from an academic inventor, one of the first things I do is I look and see what they've patented or published before, because if it's been more than a year since that previous publication, it's prior art. It can be used to take down the patent as being lacking novelty or obviousness, as if it was written by somebody else. So this is another key lesson, that in the patenting world, your own prior disclosures are super dangerous if you're trying to build on your previous work with subsequent patent filings. You need to make sure that if your previous work, be it a paper or a patent, if it's been more than a year since it's published, it's as if somebody else wrote it, and it's going to be held against you. So you got to make sure that your new invention and your new claims that you're drafting for that new patent application you're filing are inventive or not non-obvious over your own previous work. Not the case in the world of papers. Importance of language is another difference. In the world of filing, submitting papers, it doesn't really matter about the language. It's, your referee might want to change some things here and there, but your paper is going to be allowed either way usually. In patenting, it's very surgical in terms of the use of words in a patent. We are super careful, especially in the claims. one word in the wrong place can basically kill a patent. So it's much more sensitive to language. And as patent agents, we spend a lot of time sweating the details on the language. Even the language and the description can hurt the claims. If we say, for example, something that is essential in the description of the patent, or that it must be included, then that can be read into the claims. It can be interpreted that that element that you described as being essential has to be in the claims, and that can unduly narrow the claims if in reality, you didn't actually intend for that to be, you wanted the claims to be broader than that. Another difference is correspondence with the patent examiner versus the reviewer of a paper. In the publication world, your statements that are made during the academic review process when you submit a paper, they're confidential. Whereas in the patenting world, the statements that are made during the review process or the examination process of a patent are actually public. So if you're a company out there and you've got a competitor that's filing patent applications and you see their published patent applications coming up and you're not sure if they're going to issue and you're worried that they're going to issue and maybe be a problem for the product you're bringing to market, you can actually go online, you can look at the status of that examination and look and see sort of what stage the back and forth between the examiner and the patent applicant is. In the paper, you have limited ability to interact with the reviewer, usually corresponding by email or written submissions. Whereas in the patent world, you can actually go and meet with the examiner in person. You can go have a formal interview with the patent examiner. And I often do this on the phone with patent examiners in the US just to save money for not having to travel down there, but it's an extremely useful process in terms of trying to negotiate a patent on behalf of an inventor. In papers, there's no need to disclose the prior work of others. So let's say you submit a paper and there's a couple of papers that others have published that you're pretty close to and you've got a pretty marginal improvement on. You don't have to tell the journal about that. Whereas in the world of patenting, you actually have to tell the patent office about this stuff. You have to give the patent office a list of any prior patents or papers that would potentially impact whether or not you're going to get your claims. So you have the obligation to submit this to the USPTO. And in the world of papers, if you fail, you can try again in a different journal, and this is what's often done, right? You start with a high impact journal, you submit, you get your rejection, you go to a different one, and sort of work your way down the list and get your paper. Whereas in the patenting world, it's very different. You've only got one shot. You've got one patent office in one country, and you need to be successful with that interaction. Okay, a couple of other differences, and then I'm going to just talk briefly about some thoughts about how to think about patenting strategically as a student, and then we'll have a few questions. Another difference is time. Papers do not expire. It's not like Einstein's theory of special relativity. His original paper has expired, and he no longer gets credit for that. It's still good. Whereas in the patenting world, patents only have their effect for a limited amount of time. Patents have a 20-year term from their initial filing date. And after 20 years, that invention goes to the public domain. Now, 20 years might seem like a really long time, but in the world of medical device development, 20 years can go by really quick because it takes such a long time to develop a complex medical device, get it through the regulatory process, get it into early adopters' hands, get all the clinical literature that you need to support the broader clinical market, embracing and purchasing that easily takes 10 years. So it's really critical to be aware of this and the limited amount of time you're actually going to, the amount of term you're actually going to have when you're out there selling your medical invention to the broader market. And for this reason, it's critical to kind of layer your patent filings, keep filing new improvements on your invention so that you're not just have one term, but you've got a number of overlapping terms that are extending into the future. Another big difference is cost. Some papers are free to publish in. Some papers you pay a few $1,000s to get your journal a submission published, and there's no recurring fees. It's relatively inexpensive. Whereas a patent application, just to file a patent application, so a properly drafted patent application, including the fees for the patent agent's time and the government fees, can easily exceed $10,000 just to file, and easily exceed $25,000 over the 20-year term. And if you're filing in multiple different countries, over that, it can easily exceed $50,000 to file. That's for like 6 or 7 countries, and over $400,000 over the 20-year term. So just a huge difference. And this might seem like a crazy amount of money, but when you think about these, the cost to have a fairly low salary employee within a company for this amount of time, it adds up as well. So I like to think of a patent in a startup company, or in any company really, as something that is contributing over the long term. And if it continues to add value in terms of it being an asset that's valued to the company, or in terms of something that's blocking others from entering the market, then it's well worth this amount of money. Patents that are actually out there and relevant to commercial products easily have a value in the millions of dollars. So, I think that helps to put this cost in better context. Okay, so gonna take a pause now. Hopefully we're all still here and people were well caffeinated before this presentation. And I'm gonna give a few pointers about thinking about your research and thinking about patenting, and then we'll open the floor to questions. So one question is, how do I know if my research is patentable? And another question is, how do I take steps towards getting a patent? So these are key questions. So, it's really hard to know to have that judgment to know whether or not your research is patentable. You can certainly do patent searching, and I would encourage you to learn how to patent search. We're going to have a tutorial on that next month. But generally, you're going to need to invest some time in learning about the patent system and how it works, and getting some perspective. And in doing that, it will become more clear. So there's no real magic answer to that question. How do I know? It's more like, how do you start to inform yourself so you get the judgment and the perspective so that you're better at making that call. So that's my advice. Learn. And if you learn about the patent system, you will definitely add value to yourself and your career, because almost any business out there, almost any institution, patenting and intellectual property is critical. And if you come in as a new employee and you're bringing a lot of that know-how, you will be adding value, and you will be having skills that others don't have, and shining as a result. So I think it's well worth investing some time and effort into learning about the patent system. It certainly helped me a lot in my career. I would say, reading articles, attending seminars like you're doing now, learning to do patent searching, and this is a key one. So reading patents in your field. I would say patents that are not in your field can seem super boring, whereas patents that are in your field and related to your area of interest can suddenly be very, very, very interesting. So read patents that are relevant to you, and sort of learn how to dissect a patent. Other things you can do are follow companies in your field, like look at venture capital deals and mergers and acquisitions, and think about the role of intellectual property and a lot of that. And then this is a key one when you're doing clinical research. There's the clinical story, but there's also the money story. There's a commercial story. And in order to launch a medical device or a medical product, the clinical piece certainly has to be there, but if there's not an economic side to it, it's not a business. So, and the intellectual property is critical in protecting that aspect of it. So I would say, as you're doing your research, think about the potential commercial value of your research. Just start exploring what the addressable market would be for your new product, or for if someone wants to build a product based on that. That'll get sort of the IP juices flowing, and you'll start to think a little bit more strategically about not just whether or not something is patentable, but does it make sense to even patent this? Is there a value? And learn from other researchers who've patented their research. So you're in a community, there's lots of other researchers in the Sunnybrook community, for example, who have patented, and buy them a coffee and talk to them about their experience. Some steps in protecting IP. So if you think you do have some valuable IP potentially, document your invention, maintain confidentiality, don't go talking about it, and don't present yet. Search the prior art to get an initial sense of patentability, and talking to your supervisor, talking to the tech transfer department is critical. There's a great tech transfer department at Sunnybrook that I'm sure would be super helpful if you came to them with even general questions. Try to, and as we've learned before, inventorship is critical. So try to establish that inventorship early. And like I said, try to understand the commercial value of the IP. And most critically, assess the IP well before publishing. And then beyond patenting, hopefully some of you are going to get into a situation where maybe you're thinking about starting your own company based on your research. So the goal there is to, you're thinking initially as a clinician or a researcher, then you start thinking as an inventor. Ultimately, you need to think like an entrepreneur. And so you start thinking about how to monetize that IP. Is it through a startup? Is it through licensing? And then if you're thinking of taking that step about, actually launching a company, you ask yourself, am I really willing to invest my time and my money to get this off the ground? And if so, go for it. And work hard at it and be strategic. And think about all the aspects that are needed for commercial success. So that's it for the advice I was going to share with you. In terms of homework, I would say search for a patent in your field. Find at least one patent that's in your field and read it in detail and try to get a bit better understanding of patenting through that experience. Review the description and review the claims and check out the difference between those two. And think about why the claims have the scope they do and if they're properly supported by the description. Another piece of homework is to review your institution's IP ownership policy to determine your own rights. So I think if you do all these things and just start learning a little bit more, you're going to be in great shape to be a patent expert very, very soon. So with that, I'm going to actually stop and take questions if there are any.
Thank you so much, Steve. That was really great. I apologize. I have an unstable connection right now, so I'm not going to turn on my video.
No problem.
Just try and save the bandwidth. But yeah, this was, thank you so much for walking us through the differences between publication and patenting. And that was very comprehensive. I do have a couple of questions for you. I guess one is, I was wondering about the main differences in developing an IP strategy for a medical device technology versus a digital health kind of technology, like a mobile application or a piece of software, for example. Like, are they essentially the same, or what are the differences? Because I know some of the people.
Yeah, there can be some big differences. I would say a couple of the big differences are going to be the categories of product lifecycle and also in terms of whether or not something can be protected by a trade secret. So the first one, in terms of product lifecycle, a lot of digital apps may have a shorter lifecycle, who knows? And maybe it might not even be relevant to get a patent. Like by the time you've got your patent, it's going to take years. By then you've sort of you've either sort of, it's past the make it or break it time as a digital health startup. So I would say patents are going to be more critical for more of a hardware based medical device company that takes years of investment before their product gets out there. Having said that, I mean, I've done a lot of patents in the digital health space, and they can certainly be valuable also. Another question in terms of reverse engineering and trade secrecy, if you've got a piece of hardware, a physical product that you're selling, generally can be reverse engineered. And if it can be reverse engineered, it probably should be patented because others are going to be able to figure it out. And if there's no patent, they're going to be able to practice it. It's very hard to keep that kind of thing secret. Whereas if you've got a digital health startup, for example, that is based on AI, and you've got some fancy AI algorithm that has, lots of smarts, buried in some deeply connected layers or some special algorithm you've got there, and it's going to be pretty much impossible for anybody to figure that out. Well, you don't want to publicly disclose that. You don't want that in a patent because you don't want to have to publish that. So that's another big difference. A third is in terms of patentable subject matter. So medical device commercialization, you need to think about methods of medical treatment. You're probably patenting more the device and the system rather than a method of using it. Whereas a digital health startup, you got to make sure that you've got enough technical description in your patent about how it's working from a sort of maybe a UI implementation or details about detailed description about how the data is being processed, so that it's not just seen as a generic algorithm and an abstract idea and kicked out of patenting, not admitted to the patent process because it's abstract. So a lot of differences, a lot of different strategies to consider in those two different areas.
Perfect. Thank you so much, Steve. Yeah, and I guess my second question was really around the timing of filing a patent. I've seen many innovators find it difficult to decide when is the good time to file, and I think part of the uncertainty comes from the fact that the R&D and prototyping is a very iterative process, and there's always a concern that patent claims might change, or when you file a patent, and is there, I don't know, sometimes people think, is there a mechanism to go back and change the claims or update the claims?
Yeah, it is a really tough situation, and this is one where there's no sort of magic answer to that question. With experience, you sort of get the judgment and perspective that makes that decision easier. The problem, one of the biggest problems with that is, if you're starting a company, you're pre-seed, you don't have money, you're maybe applying for grants, you're trying to get people interested in the idea, so you actually have an urgent need to publicly disclose it, because it's going to be hard to get financing for it without telling people what it is. Yet at the same time, you don't have the funds to do a proper patent application yet and support the filing of a patent application. So, this is where I come back to this question of how committed are you to this? Like if this is a personal thing that you're taking on this research and want to run with it, if you really feel committed to it and you're potentially going to spend a couple of years of your life going for it, then it's worth putting the effort in and finding a way to cobble some money together to do at least a partially full job on the patent application, to try to do as good a job as possible. I would say try to find a patent agent that's going to sort of work with you on some kind of discounted basis to help get you sort of over the initial hump. In terms of doing this within an institution, that's a challenge as well, just from setting aside all the funding and sort of the disclosure issues that go along with needing to excite others about the technology to get funding. The question you were asking really was just about the stages of development, and how do you know if there's going to be iterative changes to the invention over time? Where do you say, okay, I've got enough to file that first patent application? And again, that I would say once you've got enough detail, like if you've sort of got that sense that there is something there and there's potentially a patent there, and you can identify sort of the broad claim, at least not writing down a claim like a patent agent would, but just saying, I think we might be able to get a patent on X, where X is has some scope to it. Do you have enough of you don't have to have made it yet. You certainly don't have to have conceived it to practice yet, but you need to be able to describe it. So are you able to describe it in enough technical detail to support those requirements for written description and enablement that would get that first patent application? That's question number one. Question number two is, how confident are you that you're not going to say something in that first filing that you're going to that's going to poison a later one? Like how confident are you that you're right that when you say something in that first patent application that there isn't going to be some inconsistency or something technically incorrect that's going to be a problem for if you come back and do it later? Because one option is you can file an initial provisional patent application which doesn't have a filing fee, and you can file another provisional and another provisional during the year, and then file a full application that incorporates all those provisional applications together, and iteratively sort of, get different intermediate filing dates for those improvements with the supplementary filings. But it's hard to do that on the first go. It's hard to be strategic about that on the first go. So I think the best thing that you can do, as I'm trying to put myself in the shoes of a student or a researcher or a grad student or a postdoc or someone who's at an institution like Sunnybrook, who's in the position where they're doing some research and thinking about this, is to do the homework, to get that perspective, talk to the tech transfer people, instead of making it a binary thing, like I've got this great idea and I need it patented, have the conversation with them and show that you're willing to help, do some of the heavy lifting to try to make that assessment and work with them and figure out, at what stage something is potentially patentable. And talk to your supervisor. Talk to those people with whom you can maintain confidentiality and that you're going to be able to bounce ideas off of and get that perspective. So again, not a very clear answer, but hopefully that helps.
No, definitely helps. I think I just have one final question. I don't see any questions from the audience, so I'll just go in one final question, just for the sake of clarity. So is it fair to say that once you submit, for example, a provisional US patent, can you publicly disclose your idea or not?
Yeah, generally, like, again, this comes down to, if you look at that, if you remember that disclosure sign I had with the slide with the sort of nuclear warning symbol, the suggestion was to make sure that you've filed your patent application with sufficient detail to support the claims before you make that public disclosure. So I would say if you've done a really good job and properly described your patent application, your invention in the provisional to the point that you could turn around and file it as a full application, you wouldn't have to change anything, and you're really confident about the support for the claims and the support for different species to support a broad genus claim, then yeah, you should be safe, right? Because you've described it, you've done the right things in terms of getting that initial date that should stand up. I would say, is it strategic to do that? Like, you probably want to only disclose when you need to and not necessarily disclose the full picture. So you want to sort of be strategic about to whom you disclose and to what extent. Do it on an as needed basis, and think about the risk in terms of how much you've actually, how thorough a job you did on that first file.
Yeah, no, and I've seen that situation happen with a couple of groups at Sunnybrook where they filed a provisional, but then they wanted to reach out to a lot of key opinion leaders, gather do some primary market research. And I remember one time they wanted to participate in a conference in the US and they wanted to present some of their findings and gather the audience feedback. And they were in this situation where they weren't sure what is the best strategy to that situation.
Well, it's a chicken and egg thing, because I like to look at global risk, not just IP risk. You got to think about what the big picture risk is to a potential venture or to a potential startup that could come out of it. Sometimes you need to take those risks in order to find out, in order to test the idea, in order to. So it's complicated is my answer. Like, you can be overly cautious on your IP risk to the point that you're not getting enough customer voice or enough test driving of the value proposition, that there's massive market risk that you're postponing too long. So yeah, I would say look at it holistically, but again, try to do as good a thorough job on that first filing as you can.
Okay, perfect. Thank you so much. That was great. Again, thank you for taking the time and generously
Always a
dedicating
pleasure.
to share this with our students. And thank you everyone for joining tonight. Please remember, MBP students, we have a tutorial in 7 minutes from now, so please go and take a break. And we have our next scheduled lecture for next week, and we're going to talk about medical device regulation. And again, do not forget, we have another tutorial class with Steve on November 19th, where we will talk about prior art search. Thank you.
And that's my email address. If you guys have any even general questions, feel free to send them my way. Always very happy to help.
Thank you so much, Steve. Thank you, everyone. Have a good night.
Okay, you too.
Bye-bye.
Bye.